The real test of justice. It isn't found in some quiet courtroom when everything's peaceful. It's really forged in the crucible, that white-hot pressure cooker is a crisis. When society is collapsing under the weight of famine or war or plague, does the legal structure you've built actually protect the weakest among us? Or does it just kind of dissolve into fear and chaos? That, I think, is the ultimate test of any judicial system. And what we found really compelling looking through our source material is this fact that 14 centuries ago, a remarkably comprehensive framework, really robust, for justice under exactly these emergency conditions. It wasn't just thought about. It was established and it was executed. It created a legal system that was basically designed never to be suspended, even when every part of society felt like it was fracturing. Welcome back to the Deep Dive. Today, we're focusing on one of the most pressing, really fundamental legal challenges humanity faces. How do you govern when things just fall apart?
Yeah, and we're thrilled you're joining us for this. It's a really crucial deep dive. Our material today, it draws heavily on a foundational legal text, one that analyzes constitutional powers. And specifically, we're zeroing in on 5 landmark decisions. We're talking cases 31 through 35. These cases, they detail the specific legal challenges that come up with these, existential threats. How do you manage mass displacement, economic famine, infectious disease outbreaks, and just the sheer necessity of quick judgment during conflict?
Right. So our mission for you, the learner listening in, is really to extract the core principles they use to make sure justice was never put on hold. We're looking for kind of the legislative DNA that guaranteed fairness and collective well-being, even when facing what we'd now call state-level emergencies.
We want to
think how they manage that balance, urgency versus justice, individual rights versus, keeping everyone safe collectively. Okay, let's just dig right into this, starting with the courts themselves, the actual mechanism. How do you keep the rule of law going when time is just incredibly tight? We turn to case 31, the principle of expedited justice.
Yes, and what's fascinating here is the immediate recognition that a crisis, it just fundamentally changes the timeline you need for resolving things. Case 31 deals directly with what we'd call emergency adjudication, this necessity of setting up swift judicial processes during crises.
Yeah.
And the context is really high stakes, urgent disputes that pop up during wartime.
Yeah, you can imagine. When armies are mobilized, resources are stretched, then disputes don't just stop, right? They probably become even more urgent. A delay could be absolutely catastrophic. It could lead to fighting within your own ranks, loss of morale, maybe even soldiers deserting if they feel their issues, maybe about property back home or family stuff, aren't being handled quickly and fairly. The source really stresses that quick resolution was just non-negotiable.
Exactly. But, and this is the key lesson, it's really a brilliant piece of constitutional thinking speed, and judgment must never equal injustice. It can't mean compromising fundamental rights. The whole point of emergency law, as laid out here, is to maintain order while upholding rights, not sacrificing rights just to get things done fast. That's the real tension.
That balancing act, it seems almost impossible to pull off, though. I mean, if I'm the judge, how do I maintain legal thoroughness? Gathering all the evidence properly, giving someone a full chance to defend themselves, cross-examination, all that stuff. How do you do that when time's measured in hours, maybe, instead of weeks? And the fighting might be happening just a few miles away. It really feels like focusing on speed would almost automatically bring in bias or lead to mistakes, bad judgments that maybe can't be properly fixed later on.
Well, that's the core challenge, absolutely.
Yeah.
And the source material doesn't just gloss over it. The principle that was established is that while certain procedural steps, they might be condensed or accelerated, maybe the timelines for appeal are much shorter, or certain pretrial discovery periods are cut, the absolute core pillars of fairness have to remain non-negotiable. Think of it maybe like this. If a modern court issues a temporary restraining order, a TRO, they do it immediately, right? Often based on pretty limited initial evidence, because the risk of harm is right there, it's imminent, but the TRO is temporary. The court is still absolutely required to hold a full impartial hearing very quickly, usually within days, making sure both sides get to present their full case. This historical framework, it sets that same kind of requirement. True constitutional power, it isn't shown when things are easy. It's shown in that unwavering commitment to upholding fairness under intense pressure. The emergency authorizes the speed, yes, but the law mandates the integrity of the judgment.
Okay, so the speed up is strictly about the process, the procedure, not the substance of the law itself. The judge still has to actually find the facts, apply the law impartially. But how was that enforced back then? Was there some kind of special review mechanism?
Yeah, the focus tended to be on simplified but very clear legal justification. The decisions had to be easy to understand. And the judge needed to demonstrate that the fundamental rights of the person involved, the litigant, were respected, meaning they had the chance to speak, to present any witness or evidence they had available, even if quickly. The systemic safeguard really was in the transparency of the decision and the shared understanding, the expectation that this faster process was only justified by the immediate, acute emergency itself. As soon as that immediate crisis eased up, the judicial process would snap back to its standard, slower, more detailed procedure.
That connects so directly to modern times, like we were saying. When a major disaster hits a huge flood, and earthquake governments often set up specialized temporary courts. They handle insurance claims, property disputes, maybe even criminal matters that come up because of the chaos.
Exactly. These are essentially fast-track justice systems. But the lesson from Case 31 is a mandate. The laws that create those emergency courts must embed fundamental rights protection right into them. If your emergency procedure allows for suspending due process, well, it's failed the constitutional test set by this ancient precedent. The goal is rapid resolution that brings stability, not rapid decisions that feel like tyranny and just breed resentment down the line. So this first case, it really sets an incredibly high ethical bar for all the other emergency measures that follow.
That's a fascinating start, focusing on protecting rights even when the judicial system itself is under immense time pressure. But okay, once we get a handle on quick justice, we have to look at securing people's actual physical survival. When people are displaced by conflict or disaster, they become instantly vulnerable, don't they? And this brings us very smoothly to Case 32 and Case 33, addressing displacement and shelter as a show. This shifts our focus from, like, the judges and courts to the broader societal duty and maybe the executive obligation, too.
Yes, this is a really powerful pair of cases because they show this evolution, this development from just spontaneous, generous compassion to something institutionalized, something legally mandated. It's the transformation of a moral feeling into a governmental requirement. Case 32, it highlights this institutionalized community obligation, the duty to provide shelter during large-scale displacement.
And the specific historical example here is quite famous, isn't it? The Ansar, the helpers of Medina, opening up their homes for the Muhajirun, the migrants who had fled persecution. Now, initially, that was an act of just profound individual generosity, a really beautiful example of neighborly love and support.
Right. And that's the key distinction. In most societies, then and now, hospitality is generally seen as a voluntary charity. It's a nice thing to do, but not necessarily required. But what the source material shows is that the leadership at the time didn't just praise the charity. They actually formalized it. They turned it into a structured, shared housing system. This institutionalization detail, that's the legal nugget here. It meant providing shelter wasn't just about voluntary goodwill anymore, something dependent on whether an individual homeowner felt like it or had the space or the resources. It became a formalized, organized societal structure managed by the central authority.
Wow, that's a huge leap.
Yeah.
Legally and socially. So you're basically arguing it changed shelter from being a gift, something you might get if you're lucky, to a binding right, something you were actually owed by the community when you were in crisis. How did that structure work? Was it just sort of moral pressure, or were there actual mechanisms for reallocating resources?
It involves something quite close to an early form of maybe resource matching and economic integration. The Ansar weren't just told to host people. They were instructed to genuinely share their economic output, their land, their crops, their labor with their new brothers and sisters. And while it was often done with real enthusiasm, the system also made sure that if one host family hit hard times, maybe their crop failed, the community structure itself, overseen by that central authority, would step in to help manage. So a key lesson here is pretty stark. Society has a binding duty not to abandon the displaced. Preventing homelessness, especially in these mass migration or disaster situations, it's established as a core social responsibility, non-negotiable.
But relying just on private homes, even if it's formalized like that, surely has limits. What happens when the sheer scale of the displacement just overwhelms even the most generous community?
And that's precisely where Case 33 enters the picture. If Case 32 established the societal obligation using private homes, while Case 33 systematically expanded that concept, it moved beyond relying only on individual homes to a more systematic, organized approach, essentially, the establishment of state-run emergency shelter.
Ah, Okay. And the source material gives specific examples of this shift, right? Like designating communal buildings, using large public spaces like mosques for shelter,
Yeah.
and the organized setup of tents for people who just couldn't be absorbed into existing private homes.
Exactly. This action confirms the principle that shelter isn't a privilege, it's a fundamental human right, and it has to be institutionally guaranteed during emergencies. When the private infrastructure of people's homes fails or is just completely overwhelmed, which, let's face it, is inevitable in a true large-scale crisis, the state must have systems ready, already planned to fill that gap. This is the crucial difference between immediate, maybe short-lived charity and planned, sustainable governance.
I want to focus on that phrase you used, institutionalizing compassion. How do you make sure that this kind of centralized, organized system doesn't just become cold and bureaucratic, impersonal, maybe even neglectful? It's one thing for a neighbor you know to help you out. It feels quite different when it's some bureaucracy managing thousands of displaced people.
That's a really important point, and that's where the human element, the spirit established back in Case 32, has to inform the structure of Case 33. The structure needed to be managed locally, ensuring that distribution was fair, equitable, and based on actual need, not just proximity or connections. Planning was absolutely key. By setting up these communal facilities and temporary housing systems before the next wave of migrants arrived or before the next predictable disaster hit, this historical precedent created an expectation that aid would be reliable, structured, and centrally managed. It effectively shifted the responsibility from just the moral heart of the individual to the mandated structure of the community leadership. That ensures continuity, even when that initial wave of generosity might naturally start to fade.
And we see this blueprint echoing so clearly today. Whether we look at the huge logistical challenges of, say, UN refugee camps, or FEMA setting up temporary housing after massive hurricanes or wildfires, these feel like modern versions of Case 33. Systematic, organized provision that's mandated because the crisis is just too big for individual goodwill alone.
Absolutely. These historical cases, they really force us to ask a crucial planning question, even today. What organizational frameworks do we need now to ensure that private compassion can be reliably channeled, turned into a collective, guaranteed public service when disaster strikes? It really asks leaders to plan proactively for crisis, not just react when it happens.
Planning for crisis.
Yeah.
It's exactly what we need to talk about next. Because once people are physically sheltered, the next vulnerability pops up almost immediately: economic security. If they survive the war or the flood, they shouldn't then be financially ruined by others exploiting the chaos. This brings us to Case 34, protecting the vulnerable from economic exploitation. And this one focuses specifically on famine price controls.
Yes, and this might be the most, let's say, constitutionally controversial decision we're discussing today, because it deals directly with economic governance, with market intervention. Case 34 tackles that core concept, state intervention in the market during times of severe food shortages or famine. It establishes very clear limits on market freedom when basic human survival is actually on the line.
And the source summary, it stakes it pretty definitively, doesn't it, that the leadership actively intervened in the market and specifically refused to allow artificial inflation tactics, price gouging, basically.
That's right. And this is profound because it sets a clear ethical and legal boundary on purely capitalist activity during an emergency. See, under normal circumstances, the economy is generally allowed to operate relatively freely, right? Prices are set by supply and demand. But when a community faces actual starvation or widespread suffering because of a genuine shortage, a famine that standard economic calculation is deemed secondary, it takes a backseat to collective survival.
Okay, but critics of intervention, both today and historically, they'd argue something like this. So if you put a cap on the price of essential goods, like grain, don't you discourage supply? If a merchant figures they can't make a decent profit hauling grain 500 miles because the price is capped too low, maybe they just won't bring it. And then the shortage actually gets worse. Wouldn't the free market argument be that if you leave it alone, the high price will eventually incentivize enough supply to come in and stabilize things? Isn't that the case against intervention?
That is the standard free market argument, yes. And it's a valid concern, certainly in non-emergency situations. However, Case 34 provides a very clear counter-justification, and it's rooted in moral law. When the profit margin is directly causing death or enabling it, that profit is legally indefensible. The intervention wasn't just about making things cheaper in the abstract. It was about ensuring that essential goods, things needed for life, were accessible to the entire population. It was about preventing the wealthy from hoarding everything and the poor from literally dying of hunger in the short term. The decision basically says that while the state should ideally work to increase supply, that's the long-term strategy, of course, in the immediate crisis, the absolute priority is to prevent profiteering. And profiteering here is defined as using the scarcity of a necessary item to impose a price that effectively shuts out the majority of the population from being able to buy it. If you allow the price of grain to just skyrocket during a famine, you are, in effect, prioritizing the right to unlimited wealth over the fundamental right to life. This decision says, no, you can't do that.
That's a really powerful distinction. It argues that the government's, maybe constitutional, duty to protect life temporarily overrides the right to unlimited commerce when resources are just dangerously scarce.
Precisely. The specific action detailed in the source ensuring fair pricing is presented as a moral and legal mandate. Profit motives must be suspended or at least strictly controlled when they endanger the survival of the community. This decision sets a vital moral precedent. The fundamental right to life supersedes the right to unlimited profit when resources are dangerously scarce. It's the government stepping in, basically, to enforce a minimum standard of distributive justice during a famine.
And the modern relevance here is just immediate, isn't it? We saw this everywhere during the early days of the COVID-19 pandemic. Governments passed emergency laws, anti-profiteering laws to cap prices on face masks, hand sanitizer, even certain medical equipment. Similarly, after a hurricane hits, governors will often issue orders capping prices on essentials like gasoline, bottled water, lumber to prevent price gouging.
The connection is absolutely direct. The legal justification used for those modern laws. It comes from the exact same clear moral imperative that we see established back in Case 34, preventing the weaponization of scarcity. When the state declares an emergency, it simultaneously asserts its authority to regulate the market specifically to protect the most vulnerable from economic harm. It ensures that human survival stays the top priority over unchecked commercial interests. It's a really powerful statement about the necessary limits of economic freedom during a collective crisis.
Okay, so we've looked at securing justice through the courts, securing physical shelter, and securing basic economic stability against exploitation. Our final pillar of this emergency governance framework turns to that threat that's often invisible, but potentially just as deadly. Contagion, disease. This brings us to Section 4, Public Health and Collective Safety, based on Case 35, which details how contagious diseases were managed.
Yes, and this case is, frankly, a stunning example of institutional public health policy being legislated proactively centuries ago. The core concept here is the implementation of early, clear public health measures, and they're centrally focused on really robust quarantine procedures. This is crisis management when facing a biological threat.
And the specific source detail here, which is presented as a foundational public health protocol, it's incredibly definitive, stark even. It dictates a kind of dual-directional quarantine, doesn't it? It says, if you hear of plague in a land, do not enter it. If it occurs where you are, do not leave.
That simple sentence, yet absolutely absolute in its mandate. It's effectively a 14th century quarantine law. It establishes clear, non-negotiable boundaries on movement and travel during an outbreak. Notice, it's not a gentle suggestion for travelers like maybe avoid this area. It's framed as a legal injunction designed to physically contain the disease by enforcing mandatory isolation right at the source.
But let's look at the legal implications there for a second. This rule immediately forces individuals to subordinate two huge concepts, things we really cherish today: personal convenience, and maybe even more fundamentally, the freedom of mobility. How did they justify such a strict limitation on individual liberty back then?
And that is the critical lesson from this case. The priority of collective safety, of keeping the whole community alive, requires individuals to surrender specific temporary personal freedoms. The ethical justification is pretty straightforwardly utilitarian, actually. The rule is designed to prevent the catastrophic failure of the entire social system that inevitably results from an uncontrolled epidemic. By prohibiting entry into the affected area, you protect the zones that are still healthy. By prohibiting departure from the affected area, you ensure that those who might be carrying the contagion, maybe asymptomatically even, don't become vectors spreading it to new regions. It's essentially a declaration that the right of the community as a whole to survive supersedes the individual's right to unrestricted movement during a plague outbreak.
But practically speaking, this requires enormous social trust, doesn't it? And compliance. For a system like that to actually work, the community has to trust that this restriction on their freedom is genuinely for the greater good. And also trust that the leadership isn't just using the crisis as an excuse to grab more centralized power. What if, say, a leader declared an area plague-ridden just to stop political rivals from leaving or entering?
That's a completely legitimate concern, the potential for abuse of emergency power.
Hmm.
And this is precisely why the clarity and specificity of the original mandate are so crucial. The rule applies specifically to a verifiable disease outbreak, a visible plague, something people could see the effects of. Its simplicity, in a way, acts as its own check. The rules are absolute, yes, but they are universally applied across the entire infected region. It doesn't target individuals, it targets the geography of the disease. It essentially institutionalizes a social contract. Individual risk, like being stuck in a plague zone, must be accepted to save the community, but the boundaries of that acceptance are strictly defined by the verifiable public health necessity, not by political whim.
And for the modern learner listening today, this couldn't possibly be more relevant, could it? We're connecting a rule from 14 centuries ago directly to contemporary mandatory isolation laws, contact tracing requirements, travel bans, border closures, the quarantine laws we saw implemented globally during the 2020s.
It is the exact same legal principle at work. The requirement for self-isolation after you've been exposed, the mandatory closure of borders, limitations on movement within designated hot zones. All these modern strategies are, in essence, reflections of this ancient definitive public health protocol. It really proves that the fundamental legal and ethical dilemma of managing contagious disease, how do you balance individual liberty against preserving collective life, it's timeless. And Case 35 provides a decisive answer from this historical perspective. Collective preservation takes legal precedence when faced with a verifiable, dangerous biological threat.
Wow. We've covered some substantial ground here. Moving from the urgency needed in the court system all the way to fighting the invisible enemy of disease. Let's maybe pull back now and try to synthesize these 5 pillars, this idea of human-centered emergency governance.
Yeah, it's been quite a journey through these cases. We've really analyzed how the system adapted, how it tried to maintain both stability and fundamental fairness, even under the most extreme pressure.
Okay, so to recap for everyone listening, we saw the Prophet Muhammad build this incredibly comprehensive framework for emergency law. It covered everything from legal procedure to social welfare, economic intervention, and public health. First, in Case 31, we got the rule of expedited justice without compromising rights. Speed is needed, sure, but due process, that's non-negotiable. A judge has to stay fair even when the clock is ticking like mad. Second, Case 32 established sheltering the displaced as a foundational societal obligation. It turned individual charity into something the whole community was mandated to do. Third, Case 33 showed the need for institutionalized emergency housing systems, using communal facilities, public spaces, to provide reliable shelter when private homes just couldn't cope. Fourth, Case 34 detailed protection against economic exploitation, using things like price controls to make sure collective survival was valued more highly than private profit during a famine. And fifth, Case 35 delivered public health protocols using mandatory quarantine. It required people to subordinate their personal freedom of movement for the greater good to preserve life during a contagious outbreak.
Exactly. And this comprehensive framework, when you look at it all together, it really represents what we could call true human-centered emergency governance. It's remarkable, not just because it existed so long ago, but because of its balance. It manages urgency with fairness. It manages scarcity with compassion. It balances individual freedom with collective responsibility. It's a structure designed to protect both the integrity of the state and the lives and dignity of its citizens at the same time.
And this, I think, is the deep relevance for you, the modern learner. We look at our current challenges, whether it's trying to manage global mass refugee crises, or preparing for pandemics that seem to be recurring more often, or dealing with the instant displacement caused by escalating climate disasters like floods and fires. And we realize that the core legal and ethical dilemmas we're struggling with right now, they are precisely the dilemmas that were addressed and legislated upon all those centuries ago.
Right. The real aha moment, perhaps, is realizing that the tools for managing crisis, tools founded on principles of social justice and collective responsibility, they aren't new inventions. They aren't things we have to figure out from scratch every time. They are enduring principles. And they force modern states, I think, to ask the same really challenging question every time a crisis hits. Are our emergency laws designed merely to enforce state power and maybe maintain a certain market status quo? Or are they fundamentally geared toward preserving the lives and the dignity of the most vulnerable people among us, regardless of the cost to convenience or commerce?
So, building on these 5 critical cases we've discussed, expedited justice, the shelter obligation, institutional housing, price controls, and mandatory quarantine, I want to invite you, the listener, to consider the modern application. Given this historical precedent,
which consistently seems to prioritize fairness and collective responsibility over, say, individual fear or market greed, where should modern governments place their legal emphasis when they design emergency laws for the next inevitable global crisis? Is your nation's emergency response plan, a principled framework designed for justice? Or is it maybe just a blueprint for suspending rights in the name of speed and control? There's definitely some food for thought. Thank you so much for joining us for this deep dive into emergency judicial procedures.
Yes, thank you. And we really encourage you to join us for our next session. We'll be continuing this absolutely essential line of inquiry.
That's right. In the next deep dive, we'll be exploring cases 36 through 40, natural disaster response and preparedness. We'll be looking at how this community prepared for and built resilience against natural calamities, moving the discussion from just reacting to emergencies towards proactive planning and disaster mitigation. Because the real test of law, it isn't found in peace. It's in how we protect humanity in times of fear. Thank you for seeking knowledge with us today. We'll see you on the next deep dive.